Your client has rented a storefront, stocked up on inventory. You've filed the articles of organization with the Department of Financial Institutions, and you're just about to hit send on an email to your client saying, congratulations, you're legal now, you're open for business. But hold up. Have you complied with the Corporate Transparency Act? Have you even heard of the Corporate Transparency Act? Hello, I'm Jeff M. Brown, legal writer with the State Bar. I'm here today with Kent Schlienger, who's just completed a terrific CLE on the requirements of the Corporate Transparency Act. The CLE will be replayed at 10 dates coming up in the future. Click on the link in the video summary to learn more. Welcome, Kent. Thanks for being here.
Thank you.
Can you tell me a little bit about the requirements of the Corporate Transparency Act? Just an overview.
Sure. A quick overview is that it's a new federal law going into effect January 1st, 2024. It's going to affect most small businesses and entities formed in the U.S., as well as foreign entities registered in the U.S. And it's going to impose a reporting obligation on those entities to make reports to the Department of Treasury through an agency called FinCEN, the Financial Crimes Enforcement Network. That already sounds ominous. And that reporting obligation is for these entities when they're formed within 30 days after formation to report information about the entity itself, but also to report information, personal information about the individuals who are 25% or more owners of that entity, and individuals who have directly or indirectly some substantial control over that entity. Also, the people, the individuals who are involved in the filing of the formation documents need to be reported as well. And this reporting obligation with respect to at least the substantial control people and the owners is an ongoing perpetual obligation of the reporting company to change any information as that information changes. So if one of those people changes their address, that has to be reported. So this is a big obligation that starts immediately upon legal formation, and it will continue through the perpetual life of an entity.
Well, and it's very broad then, and it's a big deal. And it's not just lawyers who are forming LLCs or S-corps for their clients. It can also affect, say, trust and estates lawyers, right?
Well, it can, because some of those lawyers form entities as part of their practice. But the other part of a trust and estate lawyer's practice is advising their clients, many of whom will own interests in companies, whether they're their own companies that they control or might have significant financial ownership interests in other companies. Their clients will be asked then by these entities to provide their personal information to the entity so the entity itself can report that to FinCEN as part of the entity's reporting obligation. So it's not only helpful for estate planning clients or estate planners because they might form the cottage LLC for the family. That's an entity that's formed by filing the documents. That has a lifetime reporting obligation. Or they just might be advising an affluent client who has a lot of ownership interests, and they might be giving advice on how they can streamline the process of having to report to all these entities that they own interests in this information. And there is a way to do that, and maybe that's the teaser for this segment, why to tune in.
Well, the last thing I want to talk to you about is you and the panelists did a good job on the CLE of breaking down what does this mean for our clients, but also what does it mean for us as attorneys, because there are some ethical implications. Can you preview one or two of those real quickly?
Sure. Well, one ethical obligation is to get the word out to our clients, our current clients, who this would be relevant to. So that is an obligation, and we talk a little bit about how to reach out to them and inform them. Other ethical obligations that come into play would be our obligations if we're collecting information on behalf of our client that needs to be reported. We have duties of confidentiality to our client with respect to that information. But then that also implicates maybe we have duties through other laws to the people whose information we're collecting. And then finally, we talked about the non-compliant client and how we deal with that client, because we know that even though we would hope our clients want to be good corporate citizens, some of them are going to resist this act. And how do we handle the resistance to compliance?
Right, great. Thanks, Kent. So a lot to unpack with regard to the Corporate Transparency Act. To learn all about it, click on the link below in the video summary to learn about the upcoming dates for the CLE. Thanks again.
Thank you.
Okay.